Article 12 to 35 contained in Part 3rd of Constitution deals with fundamental rights. These are right to equality, including equality before law, prohibition of discrimination on ground of religion, race, caste, sex, place of birth, equality of opportunity in matter of employment. Okay, so let's go through what are the fundamental rights. They are the basic human rights enshrined in Constitution of India में. They are applied without discrimination on basis of race, religion, gender. Significantly, fundamental rights are enforceable by courts. कुछ conditions होते हैं but they are enforceable. Why they are called fundamental rights? Because they are enshrined in the constitution which guarantees them. They are justiciable, enforceable by courts. In case of violation, a person can approach a court of law. List of fundamental rights: Article 14 to 18 right to equality, 19 to 22 freedom, 23 to 24 against exploitation, 25 to 28 freedom of religion, 29 to 30 cultural and educational rights, Article 32 right to constitutional remedies. Why right to property is not a fundamental right? There was one more fundamental right in the constitution, that is right to property. However, this right was removed from the list of fundamental rights by 44th Constitutional Amendment Act. This was because this right proved to be a hindrance towards attainment of goal of secularism and socialism, redistributing property equitably among people. Right to property is now a legal right and not a fundamental right. Introduction to 6 fundamental rights, Article 12 to 35. Right to equality, Article 14 to 18. Right equality guarantees equal rights for everyone, irrespective of religion, gender, caste, race, or place of birth. It ensures equal employment opportunities in the government and ensures against discrimination by state in matter of employment on basis of caste, religion, etc. This right includes abolition of titles as well as untouchability. Now, right to freedom, Article 19 to 22. Freedom is one of the most important ideals enshrined in the democratic society. The Indian Constitution guarantees freedom to citizens. It includes many rights like freedom of speech, expression, assembly without arms, association, practice any profession, reside in any part of the country. Okay, then right against exploitation. This right implies prohibition of traffic in human beings, bekar, other form of forced labor. It also implies prohibition of children in factories. The Constitution prohibits employment of children under 14 years in hazardous condition. Right to freedom of religion indicates secular nature of Indian polity. There is equal respect given to all religions. There is a freedom of conscience, profession, practice, propagation of religion. State has no official religion. Every person has a right to freely practice his or her faith, establish and maintain religious and charitable institutions. Cultural and educational rights, Article 29 to 30. These rights protect the right of religious, cultural, and linguistic minorities by facilitating them to preserve their heritage and culture. Educational rights are for ensuring education for everyone without any discrimination. So ये rights किसके हैं? Religious, cultural and linguistic minorities के. उनके heritage और culture को facilitate करते हैं. Right to constitutional remedies. If citizen fundamental rights are violated, the government cannot infringe upon or curb anyone's rights. किसकी भी right को infringe नहीं कर सकती government. When these rights are violated, the aggrieved party can approach the courts. Citizen can even go directly to Supreme Court, which can issue writs for enforcing fundamental rights. Feature of fundamental rights: they are different from ordinary legal rights in the manner in which they are enforced if a legal right is violated. The aggrieved person cannot directly approach the Supreme Court bypassing the lower courts. He or she should first approach the lower court. Some of the fundamental rights are available to all citizens, while the rest are for all persons, citizen and foreigner. Fundamental rights are not absolute rights. They have reasonable restrictions, which means they are subject to conditions of state security, public morality, decency, friendly relation with foreign countries. They are justiciable, implying that they are enforceable by courts. People can approach the Supreme Court directly in case of violation of fundamental rights. Fundamental rights can be amended by Parliament by a Constitutional Amendment Act, but only if the amendment does not alter the basic structure of the Constitution. Fundamental rights can be suspended during national emergency. but the rights guaranteed under Article 20 and 21 cannot be suspended. Application of fundamental rights can be restricted in an area that has been placed under martial law or military rule. Fundamental rights available only to citizens. Following is a list of fundamental rights that is available only to citizens. Prohibition of discrimination on ground of race, religion, caste, gender, place of birth. Article 16, 19, 29, 30. Importance of fundamental rights are very important because they are like the backbone of the country. They are essential for safeguarding the people's interest. According to Article 13, all laws that are violative of fundamental rights should be void. Here there is an express provision for judicial review. Supreme Court and the High Court can declare any law unconstitutional on the ground that it is violative of fundamental rights. Article 13 talked about not just laws but also ordinance, order, regulation, notification. Amendability of fundamental rights. Any change to fundamental rights require a constitutional amendment that should be passed by both the House of Parliament. Amendment bill should be passed by a special majority of the Parliament. As per the Constitution, Article 13 Clause 2 says that no laws can be made that takes away fundamental rights. Question is whether a Constitutional Amendment Act can be termed law or not. In Sajjan Singh case of 1965, Supreme Court held that Parliament can amend any part of the Constitution including fundamental rights. But in 1967, Supreme Court reversed its stance taken earlier when in the verdict of the Golaknath case it said that the fundamental rights cannot be amended. In 1973, a landmark judgment ensued in the Keshavanand Bharati case, where the Supreme Court held that although no part of the Constitution, including fundamental rights, was beyond the Parliament's amending power, the basic structure of the Constitution could not be abrogated even by a constitutional amendment. This is the basis in the Indian law in which judiciary can strike down any amendment passed by Parliament that is in conflict with the basic structure. In 1981, Supreme Court reiterated the basic structure doctrine. It also drew a line of demarcation as April 24, 1973, that is the date of the Keshavanand Bharati judgment, and held that it should not be applied retrospectively to reopen the validity of any amendment to the Constitution which took place prior to that date. Doctrine of severability. This doctrine that protects the fundamental rights enshrined in the Constitution. It is also known as doctrine of separability. It is mentioned in Article 13, according to which all the laws that were enforced in India before the commencement of the Constitution, inconsistent with the provision of the fundamental rights, shall to this extent of that inconsistency be void. Shall to the extent of inconsistency be void. This implies that only the parts of the statute that is inconsistent shall be deemed void and not the whole statute. Only those provisions which are inconsistent with fundamental rights shall be void. Doctrine of eclipse. Doctrine states that any law that violates fundamental right is not null or void ab initio but is only non-enforceable. It is not dead but inactive. This implies that whenever the fundamental rights which was violated by the law is struck down, the law become active again is revoked. Another point to note is that doctrine of eclipse applies only to pre-constitutional laws that were enacted before the constitution came into force, and not to post-constitutional laws. This means that any post-constitutional law which is violative of fundamental rights is void ab initio. To conclude, to know how many fundamental rights are there in Indian Constitution is a must do. So stay tuned, subscribe the channel. It will be really helpful for preparation as the whole chapter is covered in 7 to 8 minutes. Thank you. Have a nice day. Take care.